Good afternoon, ladies and gentlemen. Welcome to yet another series of discussion from the East Africa Law Society. The East Africa Law Society, as the umbrella professional body uniting advocates across the region, endeavors to promote the rule of law and human rights as a core mandate of its establishment. Joining us today is an eminent panel. And before I introduce them, allow me to welcome everybody who has joined us. We have a cross-representation from across the region: Kenya, South Sudan, Burundi, Tanzania, Rwanda, DRC Congo. Welcome on board. To the French speakers, bienvenue à tous. Je souhaite la bienvenue à tous les avocats, aux avocats du Burundi et même aux avocats congolais. Pardonnez-nous, nous continuerons la séance en anglais parce que cette langue-là est la langue de communication au Kenya, la langue officielle et la langue préférée au Kenya. Donc, pardonnez-nous, on va continuer en anglais, mais j'espérais que nous allons être ensemble pendant toute la session. Merci beaucoup. Thank you very much for those who have joined us. We are going to start today's session. Joining us online, we have Professor Ben Murumbi Sihanya. Professor Sihanya is a teacher of law for many years from the University of Nairobi, and is a practicing advocate and has accomplished a lot in his stellar career. Professor Sihanya, welcome.
Thank you so much. Yeah, it was asking me to register every time I needed to join. Thank you so much, Mr. Gada. I'm pleased to be here on this forum.
Thank you, Professor. Thank you, sir. We then next have the Dean, Kabarak Law School, Professor Osogo Ambani. Professor Osogo Ambani, welcome. Thank you very much, Professor Ambani. Professor Ambani is a publisher and a prolific author of No Mean Feat. We are always honored to have Professor Ambani on board. Next, we have Miss Julie Soweto. Miss Julie Soweto is a human rights practitioner, a respected advocate, a true and tested soldier for the rule of law and human rights, not only in Kenya, but the region at large. Miss Soweto, welcome.
Good afternoon, everybody. I'm glad to be here. Thank you, Evans.
Thank you, Miss Soweto.
Good to see you again.
Thank you. Good to see you, Miss Soweto. Next, we have my brother and my good friend, Dudley Ochiel. Mr. Ochiel is a litigator and a researcher with Katiba Institute, a seasoned advocate in all courts, Supreme Court, Court of Appeal, and also with the regional courts. Mr. Ochiel, welcome.
Thank you, Evans. I'm glad to be here.
Thank you, Mr. Ochiel. Good to see you. Now, you should have noted that we had one other lady in the notice that was sent out. This is Miss Melissa Ngania. Unfortunately, Miss Ngania is not able to join us because she had to attend to an urgent call of duty at the Court of Appeal today in the afternoon. So we will continue with those that are present. Now, the Rule of Law and Human Rights Committee of the East African Law Society tries to maintain our cradle of belief and faith, that we have to express ourselves freely so that we can encourage openness, accountability, and transparency in the governments across the region. Indeed, our cradle of belief in the rule of law and human rights is supported by, among other instruments, the East African Community Establishing Charter, the African Charter on Peoples and Human Rights, and of course, the bedrock, the touchstone of freedom of expression, Article 19 of ICCPR. Those will be the guiding fundamental principles that we will organize our discussion today. We are going to have a free, open, and candid discussion. We start with the first question, and I will pose that question to each of the participants in no particular order. Participants, we need to end by 4. So I will kindly ask that we be brief, about 3 minutes for each question, so that we might cover as much ground as possible. So I start with Professor Sihanya. Oh, I'm sorry, terribly sorry, please forgive me. I almost forgot Mwalimu Elisha Ongoya. It is pure inadvertence. Mwalimu, forgive me. Mr. Elisha Ongoya is a teacher of law at Kabarak University, my co-counsel, somebody who stands with me when I do battle, and he taught me at Kenya School of Law. Mwalimu Ongoya, my apologies. Welcome, Mwalimu.
Shukrani sana Evans Ogada, nafurahia kuwa hapa.
Asante sana Mwalimu, na uniwie radhi. Now we will start with the first question. The first question goes to Professor Sihanya. What is your general view of the Supreme Court verdict?
Okay. Good afternoon once again, Mr. Ogada, advocate and lecturer. I hope you can hear me.
Yes, we can hear you, Professor.
Yes. So thank you so much. So and also fellow contributors to this panel, as well as those who are participating as listeners and viewers. This is a very important debate, and let's just the question of presidential election petition in Kenya. And on the specific question of my general view on the Supreme Court verdict, I want to approach it in a three-pronged manner. Number one, the question of constitutional fidelity to the Constitution on a presidential election petition. The second one is a question of procedure and evidentiary questions, briefly, because those issues will recur. And the third one is the question of the language and attitude of the court, the court's posture. Briefly, there is a lot of inconsistency in, if you look at the determination and also you compare the determination with the final decision, the judgment, there is inconsistency between the two, but also on presidential election petition, but also on Raila 2017, Mwau 2017. Of course, there is also Raila 2013. And then you also compare that to the decisions of the Supreme Court, which have been very influential in presidential election petition and related issues. For example, Maina Kiai. And then you also compare these to the very recent decisions where the court seems to have been applying its mind on constitutional fidelity, fidelity to text, fidelity to structure, and fidelity to history, as opposed to rhetoric. And you can look at, for example, Sonko decision, which was quite sound in my view on the question of leadership and integrity, which are
Is Professor Sianya with us? We seem to have lost Professor Sianya.
I'm back. I don't know what the problem was. Huh?
Yeah, okay, please go on, Prof.
So I was saying that if you look at this court's its own decisions, this bench, this 7-judge bench, even its own decisions in Sonko, its own decisions in recently in Muruatetu, its recent decisions on CDF, you will see a court that was really interested in looking at the Constitution very clearly in terms of text, structure, and history. And actually, on the morning of the Supreme Court determination, I was on NTV and I said, if this court were to be consistent and implement fidelity to the Constitution, the petitions would succeed. Then let me briefly go into the question of you know, of course, I know, you know, all of us know about the Sonko. It's about the issue of leadership and integrity, the issue of somebody having been impeached, the question of so many ethical and leadership and integrity issues, and then saying that you can't run for office. Muruatetu was about the mandatory death penalty, which the Supreme Court and lastly, on that issue, there is the CDF case, which the Supreme Court found that rightly, in my view, that the legislature should focus on legislation and that CDF is unconstitutional. So I hope you can hear me because there is a technological problem. I don't know what has been happening here. Hello?
We can hear you, Prof. We can hear you, and thank you for your opening remarks.
Fine, just a brief one. Just
okay, sir.
To wrap up, the issue of procedure, when the Supreme Court opened the hearings and the way they conducted the hearings, there was also reasonable. There were a few problems, but they were generally reasonable in terms of conducting the matter, and they cautioned all of us to be courteous, etc., etc. There were a few problems. For example, when one of the judge was completely not willing to listen to any issues about scrutiny, when there were serious complaints about scrutiny, and some people started saying, "What's the problem?" If there's a problem about scrutiny, surely it ought to be pointed out much earlier. And it was also very intriguing that the scrutiny decisions and report was left for the last day. Ordinarily, scrutiny, because it's an application which will affect the petition, ought to be heard and determined as soon as possible because it has serious impact on the. So procedurally, there was a big problem on the handling of the scrutiny and serious complaints about the way the scrutiny was conducted. On evidentiary issues which will recur, the standard keeps shifting, and this court ought to have been consistent, and because it is an election petition. This is not a criminal trial. It's not an election about election crimes. It's about election petition and the relevant standards on accuracy, etc., etc. The last point for me just now, and there was a problem, the question of the language of the court. The court had told us early that we ought to use courteous language. And most of those judges have cautioned advocates and parties in so many cases not to use language which is not courteous to either the advocate on the other side or to use such language with respect to another party. But here is a court that went and talked about hot air, sensational, and we all know these things. And this is really not how, especially a court which is a court of first instance in a presidential election petition, and it's also a court of last resort, first original jurisdiction and final jurisdiction on presidential election petition, ought to have conducted this matter. Actually, related to that is the issue of the court really going overboard to really castigate witnesses, castigate advocates. I'm talking about John Gidongo. I'm talking about advocates Julie Soweto, Arnold Luchengo Oginga, advocate Celestine Anyango, and the court going as if it was. I think even a respondent should not have used the kind of language the court used. And even if there were any problem, because we give evidence on the basis of knowledge, information, and belief, and you give the basis of that knowledge, information, and belief. And if the court was interested in going deep into this, surely these officials, court officials, advocates, and the witnesses ought to have been given a hearing rather than going almost to declare that they had perjured or they had committed perjury or they were in contempt. This was really quite unprocedural, quite unconstitutional for a Supreme Court to do that. I think let me leave it there for the time being, and we hear other panelists. Thanks.
Thank you very much. Sorry, thank you very much, Professor Sihanya. Professor Sihanya enjoys leverage with me because he taught me 2 times. The rest of the panelists, that might not avail. Please, let's keep it short, 3 minutes for every question so that we cover much ground. We are supposed to be ending this at 4 o'clock. That same question, I posed the same question to Julie Soweto. Ms. Soweto, are you with us?
I'm still here.
Thank you. Can you hear me? we pose the question, what's your general view of the decision by the Supreme Court?
Okay, I did very well. General view about this particular presidential petition decision will be marked by the questions that it raised, rather what it. I look at it in terms of the questions.
We seem to have lost Ms. Soweto. Ochel, can you hear
sorry.
me? Okay. Please go ahead.
My internet connection is unstable. Perhaps, Evans, you can give me a minute so that I can switch my connection and go with someone else.
Okay, Syrian. Dudley Ochel. Mr. Ochel?
Yes, Evans.
The question to you, what's your general view or your general take of the Supreme Court decision?
I wasn't expecting that question, Evans, and I think I'd requested you to spare me from it, but things happen anyway. I think the decision was a chance missed, especially on the aspect of standard of proof, which was meant to be the second question we are going to. I say it was a chance missed because Kenya has separated the petition jurisdiction from the criminal election offense criminal jurisdiction. It was separated because the court in 2013 ordered that separation. The court found that when hearing the petition and the court finds you guilty of an election offense, then what happens to you when you're now taken to a criminal court proper to be prosecuted for election offenses? The court found that in accordance with the Autrefa convict principle, I hope I'm pronouncing it correctly, that it's improper to have an election petition court adjudge guilt and then subject you to a second trial at the criminal court. So the court ordered Parliament to effect change to Kenya's Section 87 of the Elections Act. Section 87 in 2013 read that in addition to any other declaration, the court would determine the person found guilty of an election offense and then report to the DPP and to Parliament and to IEBC. That law was amended by deleting all offenses from the Elections Act, save for the offense of double registration as a voter. Now, that is not the kind of offense that someone would plead in an election petition, that a voter A was registered twice. And so now we have an Election Offences Act where the DPP has 2 years to prosecute offenses. And Section 87 now reads that the court may determine if an offense in the nature, if something in the nature of a criminal offense may have occurred. Yet the Supreme Court says that if you allege an electoral offense, then for the court to order that something may have happened, which the DPP should investigate, then you must prove beyond reasonable doubt. You must prove beyond reasonable doubt that something may have happened. It's paradoxical. It's a missed chance. The court missed the chance to relate Section 87 of Kenya's Elections Act to the requisite standard of proof. And the court says that in this, we are aware that other jurisdictions have adopted other standards of proof, but those jurisdictions, like India, for example, like the UK, retain the dual jurisdiction. The election petition court can sentence you, can convict you and sentence you within the petition proceedings, so that where you allege an election offense, because the court has a quasi-criminal jurisdiction, that standard of proof is necessary, the high threshold, because of the penalty. In Kenya, there's no use for it. What does the court need proof beyond reasonable doubt for, when all it needs to do is to determine if something may have happened? And the other thing is that it means then that the Kenyan parliament wasted words, acting on the Supreme Court direction to separate the two jurisdictions. It wasted words in shifting from the court shall determine the person adjudged guilty to the court may determine if something in the nature of a criminal offense may have occurred. This is the first time a court is finding that parliament can waste words. Thank you.
Thank you very much, Mr. Chiel. Asking the right questions, wasted opportunity by the Supreme Court. I hope Ms. Soweto is back.
Yes, Evans, I'm back now.
Thank you.
Sorry about that.
The ball is in your court now.
Yes, so I was saying earlier that this particular presidential petition decision or cycle is marked for me by the questions that it raises, the things that the court did that force us to go back, and there's certain discussions we need to have. And some of those questions for me are, I have at least three. First of all, I think we need to start with one that I have been grappling with, which would probably make it a fourth question. Number one is the court gave a judgment on the 5th of September 2022 with reasons, and then reserved for itself time to deliver supposedly a detailed judgment. And I think as legal scholars, we need to ask ourselves, what is that? I mean, is that even allowed by the law? Because the rules of the Supreme Court seem to allow the court to either make a determination without reasons or give a determination with reasons. So it seems that the court opened up space to have two bites at the cherry. And that is a question I don't want to delve into, but it's something that I think we need to ponder, because we also need to ask why. The second question that I think this season raises for me, and this is in comparison with all the other presidential election petition cycles, is that we're now seeing a pattern in how the Supreme Court treats certain litigants. And we want to ask the question, or at least I am asking myself the question. I saw this in 2017, and I saw this again this year. Why are judges hostile to some litigants? For instance, you know, and their advocates give short shrift to the amicus briefs. Why? We need to ask these questions. Another important point for me, which is probably the most important, is that twice the Supreme Court has ordered a scrutiny and then surrendered to the IEBC. And the question becomes, why order a scrutiny if the court does not have the technical expertise to, one, understand the technology and the games that would be played? The inordinate power that IBC has stems from its possession of public information, which it then holds or withholds to hide its culpability. So the question becomes, what is the use of a court that refers to record power imbalance between the IBC and the litigious or the litigants? And this was terrible in 2017, but it happened again this year. And then the final issue that I think we would need to, and with time, we'll engage some more on in forums such as this, is the conduct of it, the court itself, and what I probably call appreciation of the position in the arena of political dispute resolution. Professor Benassi had on this a little bit, when he talked about the court presidents in the last instance, so that there is a position that it occupies, which coupled with our history would inform the conduct itself. Those are the things that for me mark my view of this presidential petition decision by the Supreme Court. Thanks, Evans.
Thank you very much, Ms. Soweto. Always good to hear from you. Thank you very much. Allow me to encourage the listeners to pose the questions in the chat function. Please pose your questions directly to each of the panelists. I am very sure if we have time, we will be responding to them individually. In the spirit of recognition of persons who have attended, allow me to recognize the presence of a venerable scholar, a scholar par excellence, Professor Jill Guy. Thank you very much for attending. Senior Buta, welcome, see you on board. Dr. Duncan Okubasumo University, welcome, thank you. Keep on posing your questions. Mwalimu Elisha Ongoya, karibu. Maoni yako.
Thank you so much, Program Director. I had the privilege of conducting a review of the pleadings and the respective affidavits of the parties to this petition under certain consultancy arrangement with one of the election observer groups, just to have a feel of what the petition was like and where it was likely to go. And this was well before the hearing ended. And I remember my verdict at that time was that I reviewed all the issues as framed by the court against the evidentiary material presented. And I didn't have a very positive picture of the possible outcome. And my question was that had a mathematical chance with issue number 6, which essentially was the issue regarding what the court called the boardroom rupture. I have thereafter had a chance to petition, and I guess when we get into the big issues, overall, the impression I got was that this petition turned on the collateral evidentiary fact of credibility of witnesses more than anything else. I think the court applied its mind significantly on the collateral evidentiary fact of credibility of witnesses. And once it chose one version of credibility as against the other version of credibility, all the other issues fell into place for the court along those lines. So the impression I got was that, number one, the court disbelieved the core witnesses of the main petitioner. And I use the word main petitioner advisedly to refer to the presidential candidate, Raila Amolo Odinga. So his core witnesses are the ones the court disbelieved. And two, the court also disbelieved the 4 IEBC commissioners. From the petitioner side, the court seemed to have believed Okia Omtata as a petitioner and as a witness, only eventually finding that although his case rose to the level of shifting the burden of proof, the evidentiary burden of proof, the IEBC responded satisfactorily. So from that,
We seem to be losing Mwalimu Ongoya. Can we hear Mwalimu Ngoya?
Fact of credibility, the court
No, we cannot.
took the view that his overall view in terms of, Mr. God, I can hear you very clearly.
Yes, we can hear you now.
I can hear both of you. Okay, thank you. So I had alluded to the fact that this petition, to my mind, turned on the evidentiary collateral fact of credibility, and that the main petitioners' witnesses were generally disbelieved by the court, and the 4 IBC commissioners were generally disbelieved by the court. From the petitioner's side, the court generally believed Okia Omtata, but then also in the final analysis took the view that his concerns, though credible in their own right, were adequately responded to by the IBC. I think I'll deal with that issues when we get into the meat and marrow of the conversation.
Mr. Mwalimu Ngoya, we lost you at the tail end, but
Mr. Gadi, I'm back to you. Are you able to hear me?
We lost you at the tail end. Did you finish, Mwalimu?
By and large, I think I had made my argument. Let me deal with the rest when we get into the pith and marrow of the arguments.
Super, Mwalimu. Thank you very much. Good to always have your insight. A crisp, clear-minded litigator, one of the finest lawyers on his feet, Mr. Elisha Ngoya. Thank you very much, sir. Professor Mbani.
Bueno Gada, I'm here. And
Maoni yako.
Maoni nimesikia wengine wakisema. Actually, it's very easy to say sina maoni because I've had both sides of the argument. Ngoya's side and my other learned colleague's side. My take though would be that, where do I start? Okay, let me give you just 2 points for now because we're going to do many issues as we go on. First on the court itself, and the court as judge here, but second on the court as the institution on trial. I think we can talk about those 2 limbs. So in terms of the first one, I have become increasingly persuaded that Kenyans are looking at the Supreme Court when it exercises this jurisdiction in 2 ways. There are those Kenyans who look at the court as a judicial organ when determining this kind of disputes. But then there are those Kenyans who also look at the court as a voter, the extended voter, that after we have failed to square our issues at the ballot, then we go to the court to determine the issue. And I think you can only assess the verdict of the court along those 2 lines. If I spoke first about the most obvious there, which is that the court as an adjudicator, I think the court did its job quite well to human standards. And I would join Ngoya in saying that I also had to analyze for my friends and those who had asked me my opinion, and I didn't see any issue surviving. I was a bit divided on what the court would say about the commissioners in my mind, but I didn't see any issue standing. So the court as a judicial organ did its job, I think, quite well, and made a verdict that is acceptable if someone was to think judicially. But then, like I said, when it comes to this mandate or jurisdiction, we don't normally expect the Supreme Court to act judicially. We expect the Supreme Court to act on our side, on our person's side. And on that case, therefore, I want to leave it open that those who support Mr. Odinga will want the court to have ruled their way, and those who support the former Deputy President, now President William Ruto, would want the court to have ruled their way. And that has been the case from 2013, 2017 up to now. If he rules for us, if they rule for us, we are happy. If they don't rule for us, we are not happy. Second, is what I say, the court now not as an adjudicator, but the court as an institution on trial. And it was going to be so, that every election petition was going to put our judicial officers on trial. And this was not an exception. And it's worse. And the first point which I need to mention here is that actually, just to quote what the late former vice president used to say, it's called Amalwa Kijana. He used to talk about the Prime Minister Raila Odinga and say, Raila attracts only two kinds of emotions. And he would say that there are those who love Raila too much, that they would kill for him. And then there are those who hate him so much that they would actually kill him. For those who loved him too much, he said Raila Mania, you remember, that was their name. Those who hated him so much, he called them Raila Phobia. And so whenever Raila then joins the trial, you're going to get that extreme emotion. And that extreme emotion goes all the way to the courts. The courts are not immune from that. And I expected that the judges were going to face trial. To be honest with you, it was a difficult one. And I remember my colleague, William Tunga, my colleague at Kabarak, although it's my senior by far. I remember that William Tunga had said that whichever finding they make, nobody will believe them. The country will always be divided. I think William Tunga said that ahead of the elections, ahead of the verdict itself. And in addition to that, Raila Mania, Raila Phobia kind of balancing to do, which puts the court on serious trial, there were other issues putting the court on in a very, very difficult place. One issue was that one of the institutions of government just failing to make sense, just failing to live to the call of duty, to the honor, to dignity that they're supposed to walk around with. And I would mention a few offices. The Attorney General. You remember that the Attorney General refuses to be part of this petition only when certain people are mentioned, like the Army General. Then the Attorney General all of a sudden is interested in this case and is now part of the case. DCI, an institution that should be very credible, that is at the heart of our criminal justice system, and therefore also just human rights system, and therefore constitution, is also involved in this case, giving evidence back and forth on one side. Then the four commissioners also walk out, okay? And that together, the public pressure that I've already talked about, put the court in a very serious place, a very difficult place. And for me, the fact that they were able to navigate all this terrain and come out with one decision, unanimous decision, I think is something I want to praise them for. Put yourself in that shoe, and it's very difficult to gather even for yourself to navigate that system. Thank you.
Thank you, Sana. Thank you very much, Professor Ambani. Professor Ambani talks of the crisis of institutions, the institutions that were expected to rise to the occasion failed at the critical hour of need. Thank you very much, Mr. Odele from Uganda. We see your questions. Panelists, feel free to look at the chat function. Certain questions have popped up there. You will, time allowing, be required to address some of those concerns. Allow me also to recognize Ms. Christine Konge. Madam ED, welcome. Thank you very much. Mr. Ball from South Sudan, welcome. Thank you very much. The Burundi Congolese advocates, soyez les bienvenus. Vous pouvez poser n'importe quelle question as we continue, so that at least at the end of the session, we will be able to respond to them. Mr. Ochiel, you had started on the standard of proof, and you called it a missed opportunity. Any further contributions to that question?
I wanted to say that what the Supreme Court of Kenya has done is similar to the situation obtaining in Uganda. In Uganda, the Ugandan Act says that when the court makes a determination on election offenses, it is not exercising a criminal jurisdiction. That nothing in this act allows the court to exercise a criminal jurisdiction. But Uganda, like Kenya like Uganda, is an outlier. They delink their determination on the standard of proof from their act. The election process is sui generis. It has a specific body of laws. For example, at the Court of Appeal of Kenya, it's only when you are appealing from an election petition where you file your notice of appeal at the court where you are appealing to. All other cases, you file it at the court where you are appealing from. So that jurisdiction is special. I've filed many matters at Kenya Supreme Court. It's only an election petition that you must file at 2 p.m. Otherwise, e-filing allows you to file all these other matters at midnight, at 3 a.m. It is only the election petition that you must file at a specific time, at midnight. In short, the election jurisdiction is specialized. There's this specific body of laws controlling it. So that where the Elections Act says that the court may determine if something of a criminal nature may have occurred, or where the Election Act says that in making this determination, in resolving a petition, nothing allows the election court to exercise a criminal jurisdiction. How can the court then set its standard of proof divorced from that proceedings? I mean, just completely shut its eyes to what the law says, the nature of determination that the court may make, and then go to Malaysia, go to India, go to United Kingdom, and while there, just pick the standard of proof without looking at the act in those jurisdictions. And seeing that those jurisdictions have specific thresholds because of the sui generis nature of their election laws, that must inform the standard of proof or how it informs. I think that's a huge gap. It's there in Uganda, it's there in Kenya. They do not in any way try to relate the standard of proof that they require to that the laws require to the standard of proof that the court imposes. And I think the answer has been given to us by the courts in Ghana. The Ghanaian courts have told us that the courts must be slow to upset the results of elections. Maybe that's why the court now, imposed the impossible thresholds. This is the injustice. The Election Offences Act in Kenya gives the DPP 2 years to prosecute electoral offences. The Kenyan petition is heard in 14 days. 7 of those days go to interlocutories and case management so that the court has about 5 days proper to hear the petition. The first of those days is given to the petitioner, the second to respondents, and the third to interveners or to rejoinders. So the petitioner has a single day to prove through affidavit evidence without calling a single witness. The same thing that the DPP, properly staffed and funded, has 2 years to establish. It is unjust and it is unnecessary. The Malawian courts have now told us that it could not have been the objective of the law to saddle a petitioner, considering the constitutional guarantee of elections free from violence and intimidation, with that and a burden that someone can never fulfill. It is not a miracle that nearly all election petitions in Africa are dismissed. Something O'Brien Kaaba has studied, the unfortunate fate of election petitions in African courts. So that the Supreme Court of Kenya has taken us to where countries like Zimbabwe, where all petitions are dismissed as soon as you mention an electoral offense. You say that a voter somewhere was bribed, you have not proved it beyond reasonable doubt, petition dismissed. You say that there was undue influence in Uganda, that a minister bought hose, jembes, and distributed them to farmers somewhere, voter bribery, not proved beyond reasonable doubt, petition dismissed. That's where we are now.
The insurmountable mountain to climb. The Supreme Court has elevated the standard too high to ask valid election questions. That is what I hear my good friend and brother Dudley Ochieng say. Ms. Julie Soweto, do you concur with Dudley Ochieng, or do you have a different view to it?
Yes, Evans, I certainly agree with the questions and the points that are given by Dudley, and he makes them very well. And those questions continue to linger. Again, we must always go back to the nature, the very special nature that a presidential petition is. The context cannot be lost. It must always be appreciated. Where we talk about, for instance, what hurdle is it that a petitioner has to overcome? This petition must be filed within 7 days of the election, and also determined by the court within another 7 days thereafter. So the court generally doesn't have time to hear or give the kind of determination that the court needs to give to an election petition within that space. And which is why, for me, it concerns me and should concern all of us, that some of the decisions or the determinations, the sweeping, very broad sweeping statements that the court makes on the basis of affidavit evidence is a question that must be interrogated. The court itself needs to appreciate how much time it has and how much leeway it has and how much evidence it has. You know, where you've not called evidence, there are certain things that you must then be careful how you say it or what you say about it. Elisha Ngoya spoke about it. I do agree with him that in this particular instance, the court chose which party to believe and decided this one is saying the truth and this one's not saying the truth. But that evidence has to also be weighed and taken in the context in which the court was deciding the matter. How does the court then decide that on the basis of affidavit evidence, without calling witnesses, one party is more believable or credible than the other? Like I said, for me, it's about the questions that are raised and how they were dealt with or handled, and the missed opportunities or the opportunities that were squandered. It is not about a party having to win. It is the position that the court occupies in terms of dispute, political dispute resolution in this country. And it is at the highest level, because it is because of the court that we found ourselves where we were in 2007, 2008. It was because of the court. Parties did not feel that they could get justice, or that there was anybody who could arbiter the political disputes fairly. Parties had been going to court and not getting justice. So this particular court has been established for the main reason. If we go back to 2010 Constitution, the main reason why the Supreme Court was established was, number one, the resolution of presidential disputes. So it's a very unique jurisdiction. It's a very unique position that I think the in the manner in which the court resolved itself or has been dealing with our presidential petitions, it must always keep in front of it. It's like the North Star, rule of thumb. Why are we here? Is it to elevate tempers, or is it to calm down tempers? Because the people are looking for a second witness to what the ballot said. Let me leave it at that for now.
Ladies and gentlemen, Miss Julie Aulo Soweto, crisp, clear, concise. Professor Sianya, we come to you. Constitutional law 101. There is what the Constitution says in terms of election and election dispute resolution. In light of the constitutional context, did the Supreme Court of Kenya get it in terms of the standard of proof?
Yeah, so thank you so much once again, Mr. Beda, and the panelists, as well as the participants who are also posting quite important comment.
Professor, could you kindly move closer to the mic?
Let me say that I agree with what
Can we hear Professor Sianya?
yeah, I think there's a problem. I think there's a technological problem from EALS end, because almost all of us are having, because my network has been very stable for a long time, but now, okay, let me just continue. I think there's a technological problem not from my end, of course. So let me just say that I agree with what Mr. Chiel said, and Advocate Judy Soweto, the two advocates, and also that let me just start by saying that I've heard what Professor Sogo Ampani said, which I also heard before from the former Chief Justice Willie Mutunga, and this was that whatever the decision the Supreme Court makes on a presidential election petition, they will always be criticized by either side. That may well be so, but let's take it from what Advocate Judy Soweto has said, that really the court must always say that why are we here? Our decision will not necessarily please everybody, but as I indicated earlier, are we exercising fidelity to the Constitution in terms of substantive law, procedural law, evidentiary law? That is what the court should be asking itself, not necessarily. Of course, the decision will be criticized. And let me be very, very clear on this. And a direct answer to Professor Sogo and to the former Chief Justice Willie Mutunga, who even recommended that election petitions should not be taken to court at all, which I think he was amending the Constitution. The people decided presidential election petitions under Article 140 to be taken to court. And Chief Justice Mutunga, after messing up in 2013, was now saying, quote, politicians don't bring your shit here. That was quite arrogant and unconsidered statement coming from a Chief Justice.
Professor Stehanya?
What? Can you hear me?
Yes, you are back.
What? Okay. I was saying that Chief Justice Willie Mutunga even made the comment in 2013 that presidential election petitions ought not to be brought to the Supreme Court or to any court at all. And that is an unconstitutional amendment to the Constitution, because the people decided that there should be Article 140, and that is the law. Election petitions, we are not like in Tanzania where they have not been bringing presidential election petitions, but there is a recommendation even in Tanzania that they be brought to court. Having said that, the court must always be aware that it has a duty, a constitutional duty, and they also have security of tenure, and they are paid for their work. And therefore, they should also just ask themselves, are we exercising fidelity to the constitutional text, constitutional structure, constitutional history, and in terms of substantive law, procedural and evidentiary law? Just briefly on this specific issue, then the court should always say, this is an election petition under 140. This is not primarily an election offense. There may be wrongs, what are called constitutional non-compliance, illegality, and irregularity. Some may even suggest a criminal offense, or may actually amount to a criminal offense. But here we are not, that's my first question. Here we are not a criminal court. We are a presidential election petition court. Number two, and therefore the doctrine of sui generis, these are special jurisdiction, only granted to the court, applies what Daniel Ochiel was talking about, Advocate Ochiel was talking about. This is a sui generis matter. It's not the standard that you expect in criminal cases, but it's more of a civil, because I know some people talk about a third standard in these issues, but there's no constitutional basis for talking of that third standard, that it's a little lower than criminal, but higher than civil standard. The question of burden and the question of standards must be understood here very, very carefully. In fact, even in a presidential election petition in 2017, Raila, and also applied in Malawi, the petition regarding Professor Mutharika, the court was saying that IEBC has a very serious role and even availing evidence, so that here, if the burden can be shifted very easily to the institutions like IEBC, so that the burden, of course, the primary legal burden, then there is the evidentiary burden, which can shift. And these are issues which the court has not examined very, very carefully. And of course, we have Wetangula, which clarified that we need to separate this. We have Raila 2013, which already that has made comments on. And I think let me just end my contribution on this by saying that the court ought to have been a little more careful in scrutinizing and telling us about this issue of burden and standard, and the fact that the burden under the Constitution, under the Evidence Act, and under the relevant laws can shift. And the main job the court is doing is mainly Article 1 sovereignty, Article 38 political rights, Article 81 and 86, and of course 140. 81 and 86 talking about the question of accuracy, the question of verifiability, the question of accountability. And all those suggest that the main job is IEBC's to even avail evidence which the petitioners may not have had. But here, the court was going all its way in the determination and in its final judgment to really mollycoddle and really basically protect IEBC. So I think that this really, I think even on the issue of scrutiny, which is a tool to get more evidence, because most of this evidence is with IEBC, a constitutional body, which has a duty. And Raila 2017 said so, Malawi Mutharika said so. It has a duty to not, you should not even tell us that where your agents give you evidence. You, election management body, IEBC, should produce that evidence. But here we see a court that was going all its way to really protect IEBC, and the way the scrutiny was done, which was, at least in 2017, under Chief Justice Maraga, they also engaged an expert in ICT. The court itself engaged this, and the process was much better. And the evidence on scrutiny came even earlier, so that it could be used in the argumentation, final submissions, etc. Those are serious issues of substantive constitutional law, procedural, and evidentiary constitutional law. Thank you.
Thank you very much, Professor Sihanya. I hope those who are taking notes are keeping tabs with the rich vocabulary that is coming from Professor Sihanya's class, Conlaw 101. Mollycoddle, that's the term we've got today. Mwalimu Ngoya, the argument is that the court, by dealing with the standard issue in the manner it did, it mollycoddled the IEBC, that the manner in which the standard issue was dealt with was topsy-turvy. It is not conceptually clear. It makes it difficult in terms of litigating in that court. That the court is basically negating what it is dictated to set under the Constitution. Your views, Mwalimu.
Thank you, Mr. Evans. I would beg to put off my video because I'm advised that my bandwidth is rather low, which is why I had a problem last time. So I'll do that right away. Evans and our listeners, two things emerge out of this discussion. One, having read the material before the court, Mr. Ochel Dudley, acting for the Amici, made a strong and compelling case for the court to depart from the pre-existing question of standard of proof. He made a strong and compelling case. The case was backed by serious comparative studies, and it took on board the evolution of our electoral law so as to justify why the court had to depart from its pre-existing standard. But the court did what it does all the time, our Supreme Court. Our Supreme Court does not depart from its positions. Our Supreme Court is very jealous of its pre-existing positions. And if one wanted case studies for this, you can see the case of Rai versus Rai, which was a case whose outcome was considered, even by the then Chief Justice, to have been an unjust outcome, but the court felt bound by the principle it had established in the case of SK Macharia versus Kenya Commercial Bank. The only judge who was courageous to recommend a departure from the standard in SK Macharia was Judge Ibrahim when he wrote his dissent in Rai versus Rai. And there are lots of other cases if you do an analysis of our Supreme Court jurisprudence. But my perspective on that question is different. This case, as I've said earlier, although the court addressed itself on the issue of burden and standard of proof generally, this case, in my reading, turned on credibility of evidence and credibility of witnesses. It follows, therefore, that my reading of this judgment was that even if the court had departed from the standard of proof set in the prior decisions in 2013 and 2017, having come to the conclusion that it did not believe the evidence of the main petitioner's witnesses, then it became an impossible task for the petition to succeed, even on the lowest threshold of evidence. Because once evidence is not credible, then it can't pass even the lower threshold of standard of proof. So that's the dichotomy that I want to say, that I agree that the case that was made by the Army Chief was a very strong and compelling case, bound by good authority, comparative study, a good grasp of the evolution of our electoral law to justify that departure. The court's refusal to depart from that standard was based on the court's history of rigidity and jealousy towards its already established standards, not peculiar to this case at all. But bottom line is, looking at the facts on which this judgment, this decision finally turned, I refuse to believe that even if the court had accepted Ochel's proposal, this petition itself would have turned any other way. Back to you, Evans.
Thank you very much, Mwalimu Ngoya. Thank you very much. Mwalimu Ngoya holds the view that even if the court had been persuaded to reverse itself on the standard issue, the Achilles heel for these consolidated petitions were that the credibility of witnesses raised significant concerns for the court. That's the position by Mr. Ngoya. I see a comment on the chat section by a person named Captain Collins Wanderi. Captain Collins Wanderi, thank you very much for your comment. On behalf of Rule of Law Committee, we wish to make the following clear, that we had invited a fair representation rather, from either sides of the divide in the consolidated petitions. If you were not here when we started, we made the comment that an advocate for the petitioners, actually my good friend Melissa Ngania, who appeared for the president, she was meant to come and give her side of the story. Unfortunately, Ms. Ngania was not able to come because she had to attend to urgent matters at the Court of Appeal. So the ELS reached out to both sides, and unfortunately, Ms. Ngania was not able to come. So we will continue with the questions. Professor Ambani, you teach constitutional law. Generally, if you were to give advice to the Supreme Court and in future litigations, how should a court dealing with an election petition deal with a standards question? Do we make it a criminal standard, or do we get an in-between, as Mr. Ochel argued, the Malawi formula?
Yeah, to be honest, Chair, it's always very interesting to listen to the lawyers. As you know, I'm a masquerader in the profession. I am more of an academic than a lawyer, and it's a whole world of difference. I've seen my brother, my teacher and senior, trying to play the two areas quite well. I'm not that talented. But listening to the lawyers makes me feel a bit sick because I think they miss the problem of the society. The problem is not where Ochel is going, certainly not where Julie is going or Sihanya. The problem is bigger. The problem is one of integrity among our people. The problem is about our institutions and how strong they are, and whether we are ready to pay the price to make them work. I'll illustrate this by just saying what we all know. Where does this thing start? Elections start a long way before. A long way before. Not on the day of elections. That's obvious, I believe. Elections are conducted by a commission that is constitutionally protected, and that is chaired by a person of the same qualifications as the Supreme Court judges, from my own understanding of the law. And that person is supposed to chair and ensure that elections are conducted in our case. I think we're dealing now 46,229 polling stations. Each one of them with a presiding officer. Each one of them autonomous and being able to declare results, isn't it? Count, announce at that polling station, and even put on that door, give the agents, coming all the way back to bombers. The system is big, the system is there, and there are all opportunities for interventions, for political action, for verification, and all together, we even have technology right there. That system should be able to give us a president. And that system, much as is legal, is also political. And political actors are the biggest stakeholders, of course, only after the people who are sovereign. At what point do we arrive and we don't trust the polling station? We don't trust the constituency, Sterling Center. We don't trust bombers. And we don't trust the chair of IEBC, who is also as qualified as the Supreme Court judges. And now we want the Supreme Court to be the one that can be sober after all the other institutions have failed. So I think it's a question of reflecting a bit about our people. What is wrong with them? Okay. How comes such a very costly, and very important exercise can and goes wrong when all these, institutions are checking and on the lookout? So the problem cannot just be the Supreme Court. I think we must begin there. I think that's the point I'm making all through. And it can't be the Supreme Court then to deal with our political mess, our moral mess, our corruption, our internal contradictions. The Supreme Court can then only do what we can do as a people. Okay, and it can't solve our mess. It can only be part of it. And when you talk to me about burden of proof and not burden of proof, I really think I'm lost on that one, and I'm really not keen on that conversation, except to leave it to the advocates who go to court every day to deal with it. But if you just allow me, Chair, I think the point I'm making here is that if another member looking like those judges has said that this election is credible, okay, I'm talking about Chebukati here, it should take a little bit more to question his verdict. It should take a little bit more. You should come up with a little bit more information before the other court that you're going to show that Chebukati was wrong. And here, even while at that, also to say that election petitions in Kenya are not a small matter. They are matters of life and death. Any inconveniences or conducting it in a way that is not set forward, or a petition could actually bring violence, and you saw that in 2007. When you have it, could bring violence. When you don't have it, like in 2007, could bring violence. It's a very dangerous thing. And it's not just something you want to wake up and now you've cancelled. And now you have not cancelled. Second thing, final thing is that we have a precedent in 2017 when an election petition is cancelled. When an election is cancelled, the main petitioner doesn't go back to the election. He boycotts the election. And we have a more shoddy election happening a second time, which the Supreme Court had no latitude but to just accept it. So it ended up accepting a poorer election than the one it actually cancelled. And that for me shows you the limitations of the court. That's really the point I'm belaboring here. Courts are limited in what they can do. They can only be as good as we are. And I think a lot more emphasis needs to go there. What is wrong with our people? Do we have integrity? we have institutions? Can they be run by people of integrity? That's where I am, Chair.
Thank you very much, Professor Ambani. And listeners, Professor Ambani should not betray his stellar credentials by his utmost humility. By no means chance, Professor Ambani is a stellar scholar of not only local measure, but international resort. Thank you very much, Professor. Always good to hear your input. Professor Ambani says, our problem is our moral compass as a people, that we cannot certainly labor the Supreme Court with an undue burden, that we need to recognize that the Supreme Court will only reflect what we are as a country. I see a lot of questions on the chat function. Please, anybody who wants to raise any question, if you want to voice your question, just raise your hand. The persons at the Secretariat will be able to free you up to ask your question on air. We continue receiving your questions. George Sino, thank you very much for your comment and question. We've seen it on the chat. I proceed to the next question, and I will ask Professor Sihanya to go fast on this. And this is the question, Professor. What should be the yardstick for assessing the democratic will of Kenyans? Do we limit it to Forms 34A, or what can we use to assess the credibility of the democratic voice that Kenyans have pronounced? Professor, over to you.
Yeah, so thank you so much, Mr. Advocate Evans Ogada. This is actually one of the key issues that we must all address as panelists, but also, of course, as Kenyans, or those who are interested in this country. Of course, I'm saying interested because I've also seen scholarship, which I call academic tourists. Academic tourists who come to Kenya, visit for 2 days during elections, and they're expert on African affairs. Quite annoying. They don't consult serious scholars like Professor John Lonsdale of Cambridge, who have empathy for Kenya. But these are people who raise funds and are well funded for their 2-day visit during an election period, and they're experts in African affairs. I don't know how many of us who have also studied American elections have been called experts on American affairs and quoted by the relevant media. We have to be clear about these issues, because academic tourists, itinerant academics have already hijacked this, and they're quoted in New York Times, Washington Post, etc., etc. And we know them. And at the right point, I'm writing an article which will mention them name by name, because they are actually hired guns. So basically, on this issue, we have to say that I think I entered through this Article 1, this mainly Article 138, and as read with 134. But again, you can read backwards. Article 1, sovereignty, you go to Article 38, political rights, 81 and 86, which the court should always talk a lot about, but you see very little about it. Issues of 81, 86, accuracy, verifiability, accountable. And because this put a lot of the burden on IEBC and put a lot of the burden on the court. And the courts rarely give us enough about this. And so the question here is that Articles 34A, 34B, 34C, ending with etc., that 34D, etc., they are very important in this process, because I have seen a comment in the chat saying that, well, if the numbers are not don't vary too much, why unsettle an election petition? This is the main problem in this question. This question is about qualitative and quantitative test in a presidential election petition. Numbers in elections ought not to be just numbers. They ought to be backed up by the relevant forms. I agree, Professor Sogo Abadi. The electoral process is a very elaborate process, beginning with the clerks, polling presiding officers, returning officers, all the way to the chair, etc. And they are supposed to have the relevant qualifications. But then, how are they appointed? we must ask those questions of process. And there were issues about appointment of especially returning officers. There were issues. And then how are the forms processed is that also an issue. It's a qualitative and quantitative test. So it's not just a question of numbers. Why don't we just sit somewhere and just fill in numbers and then say the election is over? No, they must go through certain process. And I think the main issue here is that from 30, this is from 34, these issues of the credibility, verifiability, accountability, accuracy of the elections was dealt with in Raila 2017, which many people have praised, even those who are not Raila supporters. And I think that point should be clear. That it's not just about Raila. Raila 2013 was criticized because of the process and evidentiary issues and substantive issues. Raila 2017 was praised even by non-Raila supporters in this country and outside this country, and has been cited in other courts. Tell me how many courts have cited with approval Raila 2013, which means this is a question of when the court makes the right decision, people will support it. I hope that's very, very clear on this issue of that there will always be criticism of a court decision. When it made the correct decision in 2017, it has been supported throughout the world. Then that was Maina Kiai about, it's not just about numbers. Its numbers are important, but those numbers must come through a process, a credible process. And I participated in Maina Kiai from conceptualization all the way to the Supreme Court, High Court, Court of Appeal, Supreme Court. And therefore, the second point here is, second last point is that Article Form 34A come from the polling station. They must have certain security features. They ought to be signed by the relevant presiding officer and of course the agents. They must have certain color. They must be transmitted from a certain point to a certain point. And that if the Kim's kits, for example, in this election petition, 2 Kim's kits have the same serial number, hey, that's a red flag. That's a smoking gun. That can't be explained from the bar as it was allowed to be explained from the bar. It must be explained with clear evidence, even from the manufacturers and everybody, not just by an advocate saying that, you know, this is a minor problem, etc., etc. Those are serious issues. If the Form 34A were to be transmitted in a color format, and most of them are in black and white, is there a problem of consistency? And Raila 2017 dealt with these issues of the standards. The standards must be the same. If there was the issue of whether these forms on transmission, they are to be in the PDF format, some are or in a different format. If the format is not followed, a technological standard to secure verifiability, accuracy, and accountability, technological accountability. Because as we know, technology is an issue of garbage in, garbage out. Technology does not replace human integrity. Technology can actually enhance integrity, the lack of integrity. So it's there to be, and technology can be manipulated. So that's the issue, and that's also con law 101, as we know. So 34A, then we do with 34B. 34B is now at the constituency level, whether by this, there should be a verification process here. And there were problems with verification between 34 at the level of 34FA and 34B. And I'm talking as somebody who was promoted to be a verification clerk at Bomas. I used all my 5 senses, probably a 6th one, to check these things. And at one point, Chebukati, who is being praised as a hero by the beneficiaries of this process, stopped the question of checking 34A against 34B. I have seen, unfortunately, the Supreme Court suggesting all these form issues should be an internal IBC issue without external verification as one of the recommendations. That is dangerous. From that promotion that I earned for 1 week as a verification clerk, I learned that election can be stolen without a sweat, and it can be a perfect crime. Jose Camargo can elect for you everybody you want, and in a perfect way, by simply do you want these forms? Do you want them to be transmitted? Do you want them in color? Give Jose Camargo enough time and they will be exactly the way you want them, and they will be internal coherence in terms of numbers. So let us be very careful. Let us also talk with what we know, not what we hear or what we think. So lastly, so 34A should be tied to 34B, should be tied to 34C. 34C then is the issue of bombers or a national. But please note that bombers is an administrative process. It does not have a constitutional grounding. And therefore, if the issue that many people call Mr. Chebukati, ABC chairman, the presidential returning officer, that's not a constitutional concept. That's not a legal term. In fact, Kenya is supposed to even work the way Americans work, whereby these forms are accurate, these forms are transmitted in the right way. Everybody has a piece of paper and a pen or a calculator doing the numbers. Here is our president. But because the National Tallying Center has become a place whereby some of these things are not processed properly. Lastly, on this issue of 34A, 34B, 34C, even in the determination of the Supreme Court on, I believe that was September 5th, they did not account for this issue of 27 constituencies. I have had so many people say that all these things were transparent, they were in the portal, there was a verification and at Bomas. Excuse me, no. The portal was stopped at one point. Why don't we respond to that? Why was it stopped? The portal, Senior Counsel Ngatia, from the floor of the Supreme Court, said, please ignore that form with Jose Camargo and one of the forms that ignore, because it's not okay. There was a form that was, he said that should be ignored by the court. Yet that form was in the portal. So if the respondents, counsel and also IBC was saying that we ignore some of the forms, which ones should be ignored? And they were in the portal. That's another smoking gun. Lastly, 27 constituencies were not tallied at all at Bomas. I heard the Supreme Court say in its determination that, you know what, these other 4 commissioners participated in all this process except the last. But even if they did not participate in the one process alone, that would invalidate that process. If they did participate in the verification of 27 constituencies, which were material, even in terms of numbers and the process, that also to have been, and if Article 138, 3C and Article 138.10 require declaration and the role of the commissioners. And Maina Kia said the commissioners is not chair of IEBC. Commissioners are commissioners, acting unanimously or acting as a majority. 4 over 7 are a majority. So all these show that there were fundamental problems with both numbers, because 27 constituencies are numbers. Those who talk about numbers, those are numbers. And they would affect both the threshold of 50% plus 1 and also the general figures. So let us be careful as we comment on this. The Supreme Court decided to go the way it went. Many Kenyans have accepted, but have agreed that it is not the right decision. You accept it for purposes of peace and so-called, I'm supervising doctoral dissertation on the concept of accept and move on in presidential election. A very intriguing concept which has been invented in this country since 2007, 2013. But there can be, it creates hot peace rather than electoral justice. Thank you.
Thank you very much, Professor Sihanya. We are moving towards the final half hour of this session. It's been a very engaging session, and thank you very much to all the contributors and the questions. We now move on to Mwalimu Elisha Ngoya. Mwalimu Ngoya, the same question. What should be the yardstick for assessing the democratic will of Kenyans? Do we rely on Form 34A or do we rely on other parameters? Over to you, Mwalimu.
I want again to request your permission, Mr. Gada, to put off my video for the sake of managing my bandwidth, so you'll pardon me for that. Yes, in an ideal world, in an ideal situation, if Kenya was a small city state like maybe Athens or Sparta, I don't have the demographics of Athens and Sparta, we will possibly just have carried out a census, a proper census, and had everybody actually announce their view on the presidential contest and get a winner. So unfortunately, ours is a fairly huge demography that requires delegation of some powers to eventually collect, tabulate, and collect for us who the winners are. Allow me to say this with a measure of finality. We have fairly elaborate election laws and rules in this country that I shudder to imagine what other reforms will infuse the necessary good manners in our electoral process. I shudder to imagine. I say this because of our own history. From the time when we had the Mulolongo or queue voting, where you queued behind your preferred candidate or their agent, and you went home, and the shortest queues were declared winners, and the longest queues the losers, and there's no videography to help you even have a second look of which queue was longer, to now. From a time when ballot boxes had to be transported from the polling station to the constituency tallying center, some of them being exchanged midway, to now where the polling station remains the sacred ground for ascertaining the will of the voters. From a time when there was disproportionate allocation of polling stations, where some people would have to be on the queue longer than others, to now where we have said a polling station cannot have more than 700 voters. I shudder to imagine that we can make this process finer and better. I think, as Professor Ambani pointed out earlier, we must shift the focus to making ourselves better people, as it were. But having said that, we have introduced the question of technology, and Professor Sihanya, I think, would have done me justice if he addressed this point for me, at least just for me, because it has disturbed me for quite a while. Part of the greatest limp of the petitioner's case was the adulteration of the result transmission system and the results in the portal. But a few days before the final declaration of the presidential election result, I heard with my own ears the running mate of the Azimio One Kenya Alliance speaking at KICC to the elected representatives under that umbrella and saying, we have won. It is just that we cannot declare. The results were there in the portal. We have tabulated and we have won. Is there a withdrawal of that statement? Is there an attempt to sanctify what was in the portal and to unsanctify it at the same time? These are something that I would also wish to understand within the broader context of what Professor Ambani mentioned earlier as our value system, because a running mate of a big political formation like Azimio One Kenya Alliance is not someone whose word can be taken lightly. And therefore, if it says that the results in this portal, we ourselves have looked at them, we have tabulated them, and on the strength of those results, we can make the call. I wonder on what ground we then turn around and say that those same results are not credible. That's number one. Number two, without auditing the entire electoral process, there were certain specified polling stations that the petitioners drew the court's attention to, and for which the court said, bring all those ballot boxes here and have a look at them. And I'm one of those people who acknowledge that there were some discrepancies in some of those ballot boxes. But I also wonder, in terms of the petitioners' own agents who participated in that scrutiny and therefore who had a first-hand account of what was contained in those particular ballot boxes, were there material discrepancies in terms of the numbers in those ballot boxes at number one? And number two, I want to go to the question that was raised by the Honorable Mr. Justice Smokin Charles Wanjala to one of the petitioners' counsel, that there then was the transmission virtually into the server of the results that was heavily impugned. And then there was the physical, what you call it, by road transmission of results to bombers. Was there a material finding that at the end of it all, there were material discrepancies in this? Because that will help us in terms of making this process slightly better moving forward, and in clarifying where the court may have, on the substance of the claims before the court, gotten it wrong. I know for a fact that Heavy Weather has been my very good teacher and friend, Professor Zihanya, about the explanation around this similarity of serial numbers. I hope I'm getting that right. Of the Kim's kits, having the explanation having been offered from the bar. But let's also not forget that the allegation itself was raised from the bar. The allegation itself didn't come out of the petition, so that the earliest opportunity to respond to it may also have been at the time when it was. So these are things that I think we must be able to interrogate in a three-dimensional manner to be able to come up to a more a realistic assessment of the court, and a more realistic assessment of the future of our electoral democracy, and more importantly, our electoral justice system. Back to you, Mr. Gada.
Thank you very much, Mwalimu Elisha Ngoya. Very, very valuable questions, hard questions from Mwalimu Ngoya in terms of what the petitioners state in public, and what chinks, what gaps exist in the petitioners' arguments. It will be remiss of me not to mention and to recognize the presence of President Emeritus of the East Africa Law Society, Mr. James Mwamu, James Agri Mwamu Senior. Karibu sana, welcome. I also want to recognize the presence of Tiakagire Hanifa, welcome. Julie Madeka, ICJ, good to see you. Thank you very much for joining us. Luciana Duo, Kabarak University, thank you very much for joining us. The various judicial officers online, we see you, we will not mention your names. Thank you very much for joining us. We certainly appreciate your presence here. We then move to the next question, because I see the preponderance of concerns have been addressed here before we go to the final question in the next 20 minutes. The question of language. George Osino has posed the same in the chat function. The question of language. This is a general question. In terms of the language that the court used, hot air, wild goose chase, was this appropriate language to have been used in a judicial setting? Dudley Ochiel, your view, candidly.
Candidly, and you've already said that we have judicial officers whose names you not disclose. Evans. Anyway, the issue of language, Julie tells us that the Supreme Court was established because of what happened in 2007, when people said we are not going to court. I mean, I think the Chief Justice had just been appointed before the election, and there was no trust in the judiciary. Osogo tells us that, Ambani, that we are taking our problems to the judiciary, but I think that's a better place to take them. That's where we should take them, because it gives us an avenue for pacific resolution of electoral disputes. It is studied and it is documented that conflicts over elections disputes over elections lead to conflict in Africa. They lead to violence, like happened in Kenya and has happened elsewhere, and to death. So that when the court is hearing the election petition, it does it in the atmosphere that enables people to move on from the election, to have the dispute resolved in a peaceful way, so that the court's language is important in two senses. One, bad language gives the feeling of bias, because bias is perceptive. It's also about perception. When the court appears outrightly hostile to one side, even if the decision is fair, and it was on the merits, there's that lingering feeling of bias. But then it also speaks to the sense of judicial duty and the oath of office. Kenya's Judicial Service Act says that when the JSC is selecting judicial officers, they must look at integrity. And integrity includes the ability to treat the public with respect. It requires judicial officers who have a sense of decorum and the appearance of propriety. Language speaks to that. But language also, in the Judicial Service Code of Conduct, requires judicial officers to treat people with dignity and respect. Now, the act of judging is about expressing anger. When you sentence someone to so many years in prison, you are expressing our collective sense of anger at their conduct. But anger, if not tamed, if a judicial officer is outrightly angry, like we saw in 2016 during the Rawal judgment, that was the case concerning when the Supreme Court, first set of Supreme Court judges should retire, 65, 70. There was a judge who was openly angry and condescending in his judgment, would read his judgment openly angry. Now there's some dangers to that. One, it leads to painting with a broad brush. Here we are saying at least Ongoya was careful to distinguish between the petitioners. But we're hearing people saying the petitioners. Which one? There were 8 sets of petitions with different petitioners, but all of them are being condemned in that sense of anger. Then it also leads, it leads to hasty decision making. You quickly make a decision which justifies your initial anger. And then you could lose or gloss over other points because you're angry. That's the way in which I take umbrage at the court's language. And the Deputy Chief Justice, who's been my client before, said that we recognize that our decision is going to hurt about half of Kenyans. But why wasn't the court careful then to choose language that would not aggravate what it recognizes, acknowledges the hurt that would occur from its decision? Thank you, Evans.
Thank you very much, my brother, Mr. Chel. Dudley, at the East Africa Law Society Rule of Law Committee, we speak the law and we speak it candidly. That's all we are all about, and we do without fear or favor. Allow me to recognize very good friends of ours across the region. Professor Dr. Moni Wekesa, Dean at DAISA, welcome, sir. Senior Sekwo Wino, welcome, thank you very much. Dr. Wayne Mutuma, Senior Lecturer at University of Nairobi, welcome, sir. Illinois, welcome. Nancy Ropp, Judiciary, welcome, thank you. The question of language. Professor Osogo Mbani, how do we communicate the language of the law in such a heightened emotional circumstance?
Chair could say many, many things. But remember my conceptual framework for the conversation today. I said that some people look at the Supreme Court as a court, like me, but many people see the judges as the final voters. Yeah, the last place to win the election. And anytime you're looking at judges as voters, then you will always miss the point. You will always feel very bad and look for the small things that they do or don't do. And I think that's the situation there. So just a few things. One is the politics. This was a political court, and it was highly politicized. You must have seen the truck, the lorry that carried the evidence to the court. I think that was a statement. It's a political statement. It wasn't a legal statement. No lawyer is intimidated by lorries. You must have seen the photo between the petitioner, main petitioner, and his lawyers soon after the petition, and the hugging that went on there. You must have seen the red carpet at KICC. That's politics. And that politics is taken to the court as well. And that's the danger. And sadly, and I don't know why you are putting me here, and on this question, sadly, I must say that even the lawyers that were in this case, some of them were taking sides. I think that lawyers, like I said, were masquerade. But last time I checked, I thought lawyers should be professionals. And that if my candidate that I love so much has a case, I should be able to ask another learned brother or sister to take over the matter and step aside. So the advocates, you know, in court were on the bar were actually also just politicians. And once you understand that context, then you also understand the language of the court. And at some point, I felt like some lawyers were playing the politics inside the court, which is so sad. You're trying to flare up public emotion through your advocacy in court. And the courts don't like that. If you meet all the judges, they don't like that because they think you're now exposing them too much. Remember, I said the court was already on trial. That was part of my constitutional framework earlier on. And the court then must treat itself properly when it's on trial, and it can lose it. And I think that could have happened somewhere or the other. That's one, politics. The court was politicized, especially by the lawyers and their client. I think they should have warned their client, by the way. They should have warned Raila Odinga not to do the politics. Or William Ruto. They should have warned Raila Odinga not to try those things he tried, demonstrations and all those kind of nonsense when court matters are happening. And I'm sorry, I speak straight. I'm an academic. I said I'm a masquerading lawyer. I'm just academic and I have to speak what I think. Secondly, was the issue of integrity. And I think that the lawyers did poorly here on the question of integrity. Going as far as forging. And last time I checked, I think lawyers were encouraged not to be witnesses because then it brings a very disturbing situation. It messes up the environment in that courtroom. But you see lawyers being witnesses and even attesting to documents that are clearly forged, and they know. And the other documents that they probably commissioned, that they should have known were logs that are being changed and forged left, right, and center. I think once you do those kind of things, then you're putting the court in a very difficult place. Having said that, I'm still trying to look for the bad language the court used. I'm an artist. As an academic, I use art, I use imagery. I have checked that thing called goose. And then I think I told Mr. Ongoya, my brother, who is my teacher of law, you know, that wild goose is actually the things he keeps. He keeps those things in his omnibata too, only that this one is wild. So if somebody says Unafata bata, what is wrong with that? Just art, just imagery. Only that bata tends to fly, so maybe you're chasing them to fly. So I don't see anything wrong. They're just saying you've taken them round and round. That's what they're saying in artistic language. You can choose what you do with it, but I think if you're just well-meaning, you get the joke and you move on. Hot air. What is wrong with hot air? I want to be taught because these are words I've used statistically myself, probably in other places. And that would be my third comment. And then the final one is that I always think that people that are losing, I don't know if you've dealt with people that are losing, they always have all manner of excuses, all manner of excuses. I remember, and I think Professor Sianya will kill me, though I love him very much. He's my good teacher. BBI, after all that mess, all they could pick is, oh, Joel Ngugi did not address the president as president. He kept calling him Mr. Uhuru Kenyatta, and that's all they're picking and making a lot of noise about. There were more issues that you need to attack on that case, not how he addressed the president. So losers always pick issues on the side to vindicate themselves, and it's a psychological feeling. It gives them confidence. It returns them back. So maybe to that extent only, I will entertain that kind of language from my colleagues. But I think the time has come when lawyers must be speaking about the actual thing. I am very mad with the issues of integrity here, by the way. I lost a lot of sleep, and sometimes I called Ongoya and asked, what's happening to your profession? How can lawyers forge in broad daylight? In the past, I remember being a small boy going to court. If something happened in court, and I would watch from the time also in campus, I found that all the lawyers would take responsibility for any mess that is done by the younger lawyers. It was very common those days that maybe if you went to that big court of appeal, that had Riaga Omolo and a small lawyer messes up, senior lawyers will come and say, forgive him, we take responsibility, he learned under me in my chambers, kindly, I will talk to him later. I expected James Orengo, for example, to purge for them. He was the senior most lawyer there, or Firoz Nurji, to purge for these young lawyers that might have found themselves in a difficult situation. Instead, what does Orengo do? He goes out and addresses the media and then again takes the political thing that he does every day. So there was a lot of misconduct, to be honest, from where I sit. And I'm sorry, I really hate no one. But since you put me this corner, I just have to say it. It was a very low moment, especially for me as a person heading a law school that is trying to bring out lawyers that are trained in values, in Christian biblical perspectives. Thank you very much.
Professor Ambani, you'll certainly forgive me for putting you on the spot. You remain my elder brother. Thank you very much, Professor Ambani.
Thank you. Forgive.
We now do the last 7 minutes of this session, and I want to take very few minutes. Panelists, please forgive me. 7 minutes is all we have, and we need at least 2 minutes for the Secretariat to address us. So I will kindly ask each and every panelist to take a minute each to give us the final comments, and then we take it to the Secretariat for concluding remarks. I start with Professor Sihanya. A minute, sir. Concluding remark. Professor Sihanya? Yes.
I'm here. I hope you can hear me.
Yes, we can hear you, Prof.
Yeah, so I hope you can also see me, because this is a closing remarks. Can you see me?
We can hear you, but not see you. No, Prof.
Okay. So we are saying that these are the closing remarks, and three-pronged approach of mine is this, that number one is that Mr. Ongoya and Professor Ambani have addressed me directly, so I need to respond that quickly. One is Advocate Ongoya, when the running mate on Azimio made reference to the portal, you will also recognize that the portal issue has been addressed in this meeting. At one point, the portal was stopped, and there was no explanation on why it was stopped. So that's an important issue, and therefore it's not very easy to verify at this point what was at the portal at what point. And I think I've also said that Senior Counsel Ngatia said that ignore some of the materials from the portal. So the portal, one can rely on some of the matters which could be verified. One can also talk about matters which may not have been verifiable. I think you also talked about the question of yeah, that's a question of whether the results are doubted, etc., etc. And there was no explanation why the portal material was the portal live streaming of the material was stopped by IEBC, and the court also did. So the question of that, Professor Ambani has addressed me on the issue of that, and address other people, not just me. Of course, he mentioned my name, that people who are losing always point at something. Please know that the BBI was not lost totally, especially in the Supreme Court, and there were arguable issues, and you will appreciate that there are so many things in BBI which this administration is looking at. Without amendment of the Constitution, they are talking of a chief cabinet secretary, which would be the equivalent of, in a way, of a prime minister. Without amending the Constitution, they're talking of a CAS, chief administrative secretary, which would be the equivalent of a deputy minister in BBI. So there are so many good things there. And I think, Professor Sogo, I think let us be very, very fair to these advocates and these witnesses who are being attacked quite a lot in the Supreme Court. If nothing else, for purposes of due process, for purposes of notice and the right to be heard in their own defense, if nothing else. And that's what makes us lawyers, especially con lawyers. We can't look at that. We can't just hear allegations of forgery without clear evidence. Forgery is a criminal issue.
Okay.
And forgery cannot be determined summarily.
Okay.
Using your own language, forgery, and many people have been saying it. Lastly, for me, forgery is a criminal offense which cannot be determined summarily. Lastly, for me, the Supreme Court talked about recommendations. There is no constitutional basis for recommendations. But suppose it was to make recommendations, either in 140 or 163. The Supreme Court itself said that they are very limited in terms of remedies or reliefs, but then proceeded to give recommendations. And by the 30 days is something that for the litigation period is something that is loaded from 14 to 30 days. That was also in BBI. They make recommendations that forms 34A, 34B, 34C, a very curious one, should only be handled administratively by IEBC. That is an amendment and without public participation of Articles 1, 10, public participation, 38, political rights, 81, 86, transparency and verifiability. So these recommendations have no clear constitutional or judicial basis, and therefore, and in any case, lastly, they seem to indicate that there was a problem with IEBC process. Some of them, like policy role, oversight role, and of the commission vis-a-vis administrative role of the commissioners vis-a-vis the administrative role of the secretariat, were there were in a statutory amendment, and they should have elaborated if they wanted to make recommendations how this should be effected. Lastly, finally,
thank you, Prof.
This has been a good session, and that these recommendations indicate that there was a problem with the decision that the Supreme Court reached. These were clear findings of a problem in the process. Thank you.
Thank you, Prof. Julie Soweto, if we still have time, a minute, final concluding remarks.
Yes, Evans. My final remarks are this. First of all, I think it's a good thing that we have this discussion, but the challenge with this discussion as well is where we have comments being made either from the bar or from outside by, without context. It can make it very unfair. And it also then looks like the one side is seeking to either, justify itself with regard to a case that's in court. I don't think that is the case. The advocates, it looks like the majority of the advocates on the platform are those who are acting for the petitioners. It's unfair then to say that this is only about the petitioners and they're coming here to, justify themselves. Having said so, I think one of the things that we must never lose sight of with regard to electoral matters is that from time immemorial, we have been seeking a way to perfect democracy and the systems in an imperfect world. The reason why we have democracy systems, we now even have an electronic system, for instance, of trying to measure, is because we find there are shortcomings in how we do things. The way it looks like right now, for instance, the last time that we can actually say we had a proper election in this country is in 2002. And we did not have an electronic system. We created the systems because we were trying to make that better. The democracy that was there was not satisfactory. It was manipulated. We got to 2013, where even after we had changed the constitution and the laws, we found there were still gaps. We came to 2017, and the court realized that even technology, which we had thought was a good answer to what we want to do, can be manipulated and misused or abused, and so that in 2017 there was a clear recognition that there was a failure of not just the humans but also the technology. Now in 2022, I think one of the things that we must take out from there is that human beings being human beings, it is not that technology is perfect. And I think this is where some of my academic friends get it wrong. Even technology, because they are managed by human beings, can be compromised or interfered with. We have birds that we talk of birds learning to fly without perching. So if I was a crook or a human being, and I accept that human beings are there, and this is what human nature is all about, all one has to do is to look at what were the gaps in 2017, what were the issues, and how do we then make sure we can do the same things that we did, but not get caught at it.
Okay.
And so it becomes, let's not just talk about things, hypothetically from the air without looking at the social context or the psychology or the political context in which we deal with. And it is also in the same role that I think when we look at the court and the questions for determination, the issues for determination, we must be very alive to these factors. The Supreme Court is not just a court of law, it's also a court that must consider the politics of the day and the issues of the day. But just because the litigants that come before the court do politics, the court does not need to descend into the arena of the litigants. It must rise above it, and that is why people go there. And we must remember and consider that the work of the court is to be a balm to the issues that are affecting the people, including if it means pacifying the people, not stir up anger or contribute to the passions, as it were. Thank you for having me on at this session. I think I've taken a little bit longer than the minute that you gave me. But I think it's good to say some of those things.
It's only fair for gender parity. We have too much men in the room. Thank you. Thank you very much, Ms. Soweto. Dudley Ochiel, you're my brother.
Quickly, Evans.
I can push you around for a minute.
Thank you. Less than a minute. Now, there's so many times during the petition when issues arose and IBC would bring material evidence. I mean, there's a time they brought a KIMS kit, told the court, we are giving you that KIMS kit, go and look at it. Another time an issue arose over a form and they brought a live form. That tells us who has the information, so that the court's decision needs to recognize who has the information in setting and upholding the standard of proof. But then there's also the danger that the standard of proof that the court has now set has the Tanzania impact. What do I mean by the Tanzania impact? If you look at Article 41(7) of Tanzania's current constitution, it says that when a candidate is declared by the Electoral Commission to have been elected, then no court of law shall have any jurisdiction to inquire into the election of that candidate. The court might have unwittingly driven us to the position where all IBC has to do is to declare a candidate elected. Then the burden to upset that election is impossible and you can't meet it. Thank you.
Thank you very much, Dudley. Mwalimu Ongoya, a minute, your final words.
Thank you. There's one person who participated in this election and who has never had a chance to explain himself, but I've had a chance to read the material and listen to him. And this man is called Arnold Ochieng Aginga. So I'll take this time to make my final remarks for Arnold. Arnold was not just an advocate in this petition. Arnold was an accredited agent for one of the candidates or the parties in this election. And therefore, when the court imposed professional advocate standards in that he swore an affidavit for the party, my sympathies always go to him. That as an agent, he had a right, an obligation to swear an affidavit on his own behalf, and perhaps in some respects, on behalf of the people who are under his supervision. I know he may never get a chance to explain himself, but I know that the findings of the court of professional impropriety on him for such a young advocate were very devastating, and perhaps that calls for caution. That when you want to make such a far-reaching consequence, I know that the fact that he was an agent does not therefore confer upon him the right to do any impropriety, but when you judge him in the framework of professional advocate impropriety, then it's only fair that you listen to him and draw the correct distinctions so that you don't hit a young professional that hard. And I know it can be very devastating for such young people. I thought it was to dedicate my last remarks to in favor of Arnold Ochenga Genga, so that at least the world gets to hear his version of the story.
Thank you very much, Mwalimu Ngoya. Your sense of fairness, and it always overwhelms. Thank you very much, Mwalimu. Professor Ambani, take us home. Final remarks.
Okay, quite simple. I still go back to where I began, values. We need good faith. We need integrity, both in the profession and even as a people of this republic. Then the final one is I want us to begin appreciating that elections are a momentous task. They're a huge task. What we do in our offices, we can't match that exercise. It's too huge. Running 46,000 polling stations, employing probably 500,000 people, drivers, technology companies, local and international, commissioners, and all that. It's a lot of task. And as we think about judging them, let's be fair. These elections, NEC examinations, census, during our days, more in milk, those were huge tasks, and we must be fair. A problem arises here and there, and I think we should not judge them too harshly. If we did, Mr. Ogada, you're a lecturer in the university, you know that even our exams cannot pass the test of rigor. Your own panel here, one person pulled out last minute. If we start asking why did she pull out, it would be very difficult to answer. I think things happen here and there, and I think we need to grow and start just working on the values, and once the right values are there, good faith, just trust that things are okay, largely, unless really malice can be proved. I think that's where I want to leave it. Thank you.
Thank you very much, Professor Ambani. The panelists, we certainly wished for more time. Thank you very much for showing up. Thank you, Melissa Ngania, in absentia. We certainly know you wish to have been here. We thank Professor Sianya, Professor Ambani, Elisha Ngoya, Dudley Uchel, Julie Soweto for showing up and for engaging in a very robust, candid discussion. The mantra of the East African Law Society Rule of Law Committee is candid speech as an exercise of the capacity of freedom of expression. That we will continue to do. We will continue to hold those in power to account, and we will always be the voice for East Africans in an endeavor to cobble up what we call the East African community and the East African community law. Thank you to the president of the ELS, President Oundo, the council, of course, the president of the East African Law Society Rule of Law Committee, Professor Sepembwa, and committee members, the secretariat headed by David Singano. To those who attended, thank you very much. Advocates from all over the region, the advocates from Burundi and Congo, merci beaucoup pour soyez ici pour la séance aujourd'hui. We certainly hope to have you in future engagements with the East African Law Society. Thank you very much for attending. Hope to see you for the next Rule of Law Committee webinar meeting. Thank you very much. You can leave at your pleasure. Thank you very much.